Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hey everyone, welcome into an all-new episode of Inheritance Solutions for a Diverse Community with Richard Hall, the founder of Bottom Line Lawyers. I am your host, Mike Leon. Richard combines extensive legal and real estate experience to help clients with estate planning and to protect their family's future. And joining us as well from the firm, the paralegal extraordinaire, David Pereira. In today's episode, we're going to be talking about how real estate fits into a California estate plan and why proper planning makes such a difference for families that own a home. Gentlemen, it's good to see you guys as always talking about this topic that I think a lot more people need to understand. Richard, I want to start with you. What should California homeowners understand about how real estate is treated differently from all the other assets that appear in an estate plan?
The single biggest difference is real estate decisions need to be in writing, whether it's a deed or a grant of some other sort. It has to be under the statute of frauds in California. It has to be in writing. And so that means taking a look at what the grant deed says. Is your properly deeded into your trust? But county recorders we deal with on a regular basis, and it's very important that you handle that correctly, because if you don't, in terms of an estate plan, they may charge you an estate transfer tax, which you're exempt from in California if you're just putting your property into trust. Also, there's Prop 19, which was recently passed in California, and an individual can leave property to family, and one of those family members, a child, can move into that property within a year, designate that they're going to be there, and avoid a reassessment. So that's another real important thing. And then looking at changes vis-a-vis community property status or the lenders. And so lenders generally are pretty supportive of trust, but they do want you to take a property out. Now you will see where someone says, well, the lender can call the loan if you've made a transfer without their permission. That isn't true with going into a trust. So you don't run that risk there. So there's a variety of things, like I've mentioned, that you really need to pay attention to in the context of real property and a trust.
David, let me piggyback on something that was said there, because I'm sure a lot of people assume you put a home in a living trust and it's such a simple step. What actually needs to happen to transfer real property into a trust correctly?
Well, there's a little bit of debate on that subject as to what's the proper instrument to do it. In our office, we like to use a grant deed. That makes sure grant deed grants all interest that there is. Others will use what's known as a quitclaim deed. We don't particularly like that, in the same way. They have some limits on them, and a grant deed is cleaner. So you need to prepare a new grant deed, and it's from the existing title holders. It's usually a husband and wife, or an individual, and you're transferring to them as trustees of their trust. And an important element of that is that they still have all the same rights that they always did. They can still buy and sell the property anytime they want, as long as they're alive. So they don't lose any power with that, but that's typically done with a new grant deed. It has to be notarized, and then it has to be recorded with the county recorder. Now, all of those are real important. And there's also usually going to be a document, we call it a P Corp, which is a preliminary change of ownership report, to let the county assessor know that it's just being transferred into a trust. You don't need to reassess it for property tax purposes, which they should not do. And as Richard pointed out on the due on sale clause, what he raised as an issue, to make myself sound real intelligent, it's the Garn-St. Germain Act, which is federal law, that prohibits a lender from calling that loan due on sale when you're merely transferring to a trust. And it's a real important 1970s statute that everyone needs to follow.
Richard, let me ask you to expand on the Prop 19 that you mentioned a second ago. Because especially on the parent to child transfers, what should families know about the property tax reassessment when the home gets passed on to the next generation?
So I want to first talk about two types of tax that people conflate all the time. One is property tax, and the other is capital gains tax. Property tax is imposed by the county. Capital gains tax is imposed by the state and IRS, and they're completely separate issues. So one of the benefits of a trust is that when you have your home in a trust or other assets as well, they get the benefit of a stepped up basis. And people think, oh, well, that's good. Then we don't have any reassessment issues. Reassessment is a different issue. So Prop 19 was passed to deal with that. And so for someone who wants to be the child, they are the beneficiary of the property. They need to move in within 1 year. They need to file a document with the county saying, I've moved in and I'm taking it subject to Prop 19. Therefore, it's not available for reassessment. And it will stay at the current value until they either sell or move out. So very important, because if you look at those two different things, capital gains tax could be a lot of money. House was bought years ago for $50,000, and yes, you could do that in California once upon a time. And today it's worth 800, and you sell it at 800. If it didn't have the stepped up basis, you're going to pay capital gains tax on $750,000. If you have the stepped up basis, which is granted in the trust, you're not going to pay any capital gains tax at all. However, if you as the child move into the house, but you don't file the proper paperwork for Prop 19, you are going to get reassessed. And that $800,000 house is now going to have property taxes of, substantially more than what your parents were paying when they were there. And it's sometimes it's a trade-off to see which thing is more important. And that's why you really need to work with someone who understands the two different types of taxes that can apply in the transfer of real estate.
David, let me ask you about secondary properties, rental homes, vacation homes. When someone owns multiple properties, what kind of planning issues should they pay attention to?
Yeah, so they're going to need to take into account whether these properties are located in the state of California or outside of California. That's going to be an important aspect. And then uh, the trustee, certainly after the death of the trust makers, rental income is going to become a factor that they're going to have to track independently while they're doing the administration of the trust. And there may be property management agreements that need to be addressed. And liability is different. So now you have property in the trust. The exposure may be a little bit higher on all of those assets together. So having good insurance in place on those properties becomes important, and maybe even a umbrella policy to offset any additional liability. Because sometimes someone will see, oh, I got injured on this guy's property. Oh, I see it's in a trust. They must be really worth gazillions. And so they're going to sue for more. So you need to make sure you have those little additional protections in play.
Richard, can you share a situation where there was clear real estate planning and it made things easier for the family? Or even a time when, let's say, there was some outdated documents, some unclear title issues, and these were all created to help avoid complications?
Yeah, there's actually a couple things to talk about there. Um, One situation, we had a man and a woman come in recently. They've been living together for 20 years, but they're not married. And so the property was held only in his name. And they always thought, well, we both own the property. They both have contributed to it. And because they hadn't done the proper paperwork for that, it became critical. The good news is they were both competent, and they're both still alive, and so we were able to cure that problem for them. But the other thing is that deed might have been done as if they originally had deeded the house, it might have been a joint tenant deed. And in that case, when one party dies, the other party automatically, by operation of law, becomes the sole owner. However, that doesn't mean you don't need to do anything. Whether it's a trust or a joint tenancy situation, you still need to put the world on notice that there's been a change. And so we file an affidavit of death of a joint tenant or affidavit of death of a co-trustor. There are things that still have to happen. And if you don't do that, you could run into a situation where a simple recorded deed could have saved you from going into probate and could have saved, you might spend a few $100s on the deed versus $40,000 on probate. It can be that dramatic, failing to make the proper planning.
David, let me piggyback because I know you love talking about probate and how much money people spend in these. So let's talk about beneficiary designations when it comes to real property, right? The title matters in this. What are some common mistakes you've seen from the title perspective that have ended up causing probate later?
Well, I think the biggest mistake is thinking that just how you hold title is going to eliminate probate. So to a certain degree, it might. Let's take joint tenancy, for example. So basically, what joint tenancy is, right of survivorship. One of the parties dies, it automatically is left to the other one. Well, what happens when both of you die at the same time? You're in an auto accident, you both die. So now what happens? Probate. So you didn't solve anything. Well, we also see joint tenancy done where, I want my daughter to get the house, and so I'll put her on title. Well, now you try to decide, well, I want to refinance it. Well, she's on title. She has a say now. You lose control over your property, and any debts that she may have may become a problem that'll attach to her property. So you want to avoid those kinds of problems, thinking that title solves it all, when the better approach is to do something like a trust or that kind of thing. So holding title to property is not a good estate planning process from our perspective.
Richard, in a previous episode, we were talking about refinancing homes. For the homeowners that have done this, and they've, let's say, also updated insurance, lenders have changed over the years, what would you advise them to double check to make sure that their trust is still matching the current records?
Well, Mike, the deed is key. But I want to go back to what David was just talking about, because California recently tried an experiment, which I don't think is working all that well, which is a kind of deed that allows a homeowner to avoid a trust. They can simply deed it to a particular person. And that has no flexibility, unlike a trust. A trust you can change anytime at will. But when you make that deed, making a change to that and recording that change is problematic for the homeowner. So there's a few rare instances where that would make sense, but not too many. Now, back to your question, in terms of a refinance and how do they check that, again, the key is the deed. So pull the grant deed. You should have a copy. Everyone gets a copy mailed to them of the grant deed when it's recorded. And look at the grant deed and look at who it's granted from, but more importantly, who is granted to. And if it says it's granted to Mike as trustee of Mike's Trust, you're pretty much okay on that. If it just says your name, it says it's granted to Mike, that's a problem. Other issues, though, could be if it still has a name on it from someone who has passed. So because you originally held the title as husband and wife and as joint tenants, we disfavor joint tenants these days. It's usually held husband and wife with right of survivorship if it's not in a trust. But the ideal situation is put that in a trust. And the second thing is to make sure that the insurance policy that you obtain on your real estate also covers you if it's named in a trust. Most do, and I honestly haven't seen that become an issue, but it could, because insurance companies, people forget, insurance companies' purpose in life is to collect premiums and not pay out claims. I mean, that's the business profile, right? And so if they can find a way to not pay that claim, they will. And so you just need to protect yourself by making sure that your policy also covers your property that is titled in the name of your trust.
David, as we put a bow on this episode, and I'll let you get the last word here, for someone that's listening to this, they own a home in the state of California. They're not sure whether their current estate plan is covering the property right now. What's the best place that you would recommend for them to start so they can start reviewing these things?
Well, they need to look at the most current deed on their house. That would be number one. I mean, if they don't have one, they can go to the county recorder's office and get one. In a lot of cases, like for ourselves here, we take a service that we're able to access all those county records and get those information pretty quickly. So if you're going to meet with like a law firm like ours, that may be something you want to ask for. So, well, I don't have a copy of my recent deed. Is there a way that you can get it? And anyone that's doing this on a reasonable basis should be able to pull that for them and see exactly what it is.
Gents, thank you as always for the time and insights on this. I truly appreciate it, guys.
Thank you, Mike.
Thank you, Mike.
Great show.
And thank you to everyone out there for listening to this installment of Inheritance Solutions for a Diverse Community. If you want to learn more or just connect with Richard and David and the team over at Bottom Line Lawyers, do me a favor, visit bottomlinelawyers.com today. Don't forget to like, subscribe, leave a review and comment, or share the episode. Who hasn't done any of this? Share it with them so that way they know. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.